Alright, today we're talking about the Constitution, the environment, and First Nations people. First Nations viewers are advised that this video contains names and images of people who've died. The framers, writing the Constitution in the 1890s, had antiquated views of nature. They saw humans and nature as separate entities. The job of humans was to dominate nature as its master. This idea stems from, among other places, the Bible, in which God gifted the earth to humans for them to fill, subdue, and rule over, and Western philosophy, in which nature was often compared to a chaotic woman who men of reason must tame. This vision of nature differed greatly from those held by First Nations people. They didn't see humans and nature as divided, but deeply interconnected. As Amberlin Kwamallina explains, rock, tree, river, hill, animal, human, all were formed of the same substance by the ancestors. Country is loved, needed, and cared for, and country loves, needs, and cares for her peoples in turn. Country is family, culture, identity. Country is self. First Nations people, however, were not allowed in on the Constitution's drafting. The document, therefore, carries with it the framers' views of nature. The environment is essentially seen as a collection of objects owned by the Crown. The Commonwealth and states manage the use and sale of these objects on the Crown's behalf. This view of nature, entrenched in the Constitution, creates problems for First Nations people. To begin, it obstructs Indigenous land rights. In the case of Warragul, for example, the Commonwealth acquired land in the Northern Territory that belonged to the Aboriginal plaintiffs. Under Section 5131 of the Constitution, the Commonwealth must provide just terms to those whose property they acquire. This is typically satisfied by monetary compensation, but the plaintiffs raised an interesting point. What if this land is not a mere commodity that can be bought and sold? What if no amount of money was just to compensate them for their land being taken? Justice Kiefel states that this proposition that just terms might not always be satisfied with the money should not be readily accepted. Gummow and Haynes stated that this issue could be left for another day. Justice Kirby was the most responsive to this argument. He said, legal interests in property belonging to traditional Aboriginals are or may be essential to the identity, culture, and spirituality of the Aboriginal people concerned. The evidence might ultimately show in this case that they do indeed love their traditional property interests in a way that conventional property is rarely if ever cherished in the general Australian community. This might oblige a much more careful consultation and participation procedure, far beyond what appears to have occurred here. Justice Kirby, however, was in dissent. The majority held that just terms were established, and the Commonwealth's acquisition of the plaintiff's land was constitutional. The conceptualization of nature embedded in the Constitution not only complicates Indigenous land rights, but fundamental questions of sovereignty, that is, questions regarding who holds the authority to make laws and govern in Australia. Both First Nations people and the Crown claim sovereignty, and both claims are rooted in their environmental perspective. First Nations laws and authority to govern are said to stem from their duty to care for the land that cares for them, this ancient reciprocal relationship. In contrast, the Crown's claim to sovereignty begins with terra nullius, the principle that entitled Europeans to take land and sovereignty off those seemingly wasting it. This stems from God's demand that humans dominate nature, which First Nations people apparently failed to do. The High Court denounced terra nullius in Mabo, but this changed little. The Crown retains sovereignty, overriding ownership of Australia's natural resources, and desires none go to waste. Despite this often treading on First Nations people's own sovereign duty to protect this environment from destruction. So where to from here? The Uluru Statement suggests that the path forward is recognizing that Crown and First Nations sovereignty coexist. This may require changing the Constitution or making treaties. Truly realizing this coexistence, however, means confronting the conflicting views of nature underpinning these claims to sovereignty. Is land an object distinct from us, or a subject intertwined with us? Is the Crown the overriding owner of the land, or are First Nations people? Does owning land come with obligations to care for that land as well? And is it wrong to see the relationship between humans and nature as one of ownership in the first place? With all of these questions, something else needs to be factored in. Climate change and other looming ecological crises have made increasingly clear that nature is not the ever-conquerable object that the framers assumed. As the saying goes, Mother Nature bats last. The planet seems to be making demands of us if we want to continue to live safely upon it. What does this mean for our constitutional system and the flawed assumptions about nature that the framers weaved into the Constitution? This will be explored in the next video.